Never sign a release upon termination without consulting an employment attorney. A presentation by Bob Benjy and Benjy Law Corporation. Disclaimers. This presentation is not intended as legal advice, nor to establish any attorney-client relationship. Rather, this is merely intended as an educational, general overview of the subject matter. If you believe you may have a claim, you should promptly consult an attorney to avoid an inadvertent waiver of valuable rights and remedies. Scope of this presentation. For purposes of brevity, this presentation is intended as a general overview of why you should almost never sign a release when you get terminated from your job until you've had a chance to review the facts of your dismissal with an employment attorney. California is an at-will employment state. This means that with a few notable exceptions, your employer can terminate you with or without cause and without furnishing you any explanation. Employers terminate employees for many reasons. Some of these reasons are perfectly kosher, such as poor performance, bad behavior, insubordination, lack of appropriate hygiene, or even for economic layoff purposes or lack of sufficient need. Sometimes employers fire employees for wrongful reasons that could give rise to a lawsuit, such as discrimination based on age, race, sexuality, or because of an improper retaliatory basis, such as where an employee gets terminated after reporting unsafe work conditions to the authorities. Employers are not obligated to offer a severance in nearly all cases, with the exception of where there is a written employment contract calling for a severance or golden parachute. Employers may terminate employees without offering any severance compensation whatsoever. Employers will often offer a severance payout anyway. This begs the question, why do employers often voluntarily offer a severance payout to terminated employees, for example, 3 months' pay? Here are a few hints. It's rarely out of the goodness of the employer's heart. There is an economic incentive for offering the severance, and there's a catch. Please click the like and subscribe button for this video. Please click the thumbs up and the bell icons for the video. This helps the YouTube algorithm provide wider distribution of the video to other folks that may be interested in the subject matter. We thank you in advance. Employers use severance as a carrot to get a release. Put yourself in a fired employee's shoes. You just got terminated. You have no backup job. Starting tomorrow, you will lose your sole source of income. But your employer, the same one that just terminated you, is offering to pay you 3 or more months of severance pay without you providing any additional services. What's the catch? In order to get the quote-unquote juicy severance check, you'll need to first sign some paperwork. The mandatory paperwork will include a release. A release is a written agreement whereby the employee will formally, permanently, and forever release the employer from any and all claims or liabilities to the employee, whether now known or existing, but not yet known. This means even if there is a claim that you are not fully aware of or have not otherwise discovered, that too will be released. You only get the check if you sign the release. Again, you just lost your only job. You're scared of your financial future. You have no idea how long it will take to get another job. You're being offered 3 or more months of salary for 0 additional work, but you first need to sign the release in order to get it. While no one likes being cornered like this, it is a fact that nearly all employees in this situation instinctively sign the release to get the check. Once you sign the release, though, you lose the right to sue. Even if you were terminated for an unlawful reason such as retaliation, even if you were wronged by your employer last year at the Christmas party, for example, sexual harassment, the moment you sign that release, even though you did so because you felt under duress given your circumstances, you will forever, permanently give up your right to sue the employer for past wrongs. This includes the right to sue for past wrongs you may not even currently know about and later discover. Reminder to like and subscribe. If you got some real value from the video and have not already clicked the like and subscribe buttons for the video, please consider doing so now. We greatly value and appreciate your support, and thank you in advance. What should an employee do in this circumstance? Ask for a copy of all the paperwork the employer is asking you to sign, and explain that you wish to review the paperwork before you make a decision on how to proceed. Ask for 5 to 7 days to consider and get back to the employer. Potential outcome number 1. If the employer declines the invitation and pressures you to sign or forget the offer altogether, that is a huge red flag. In this case, you should seriously consider walking away without signing, even though that may mean you never get that severance. Potential outcome number 2. Most employees will cooperate with your request for a copy and time to consider. Doing so signals a transparent relationship and is a good sign that the employer is not trying to pull the wool over your eyes. If the employer cooperates with your reasonable request, promptly see an employment attorney to analyze whether you may have a wrongful termination claim or other claim that you need to preserve. Questions to explore with your attorney before signing. Assume you had time to see an attorney. You and your attorney will discuss the circumstances of your termination. Your attorney will inquire about what led up to the decision to terminate, whether you were being compensated according to law, what reasons, if any, were given for your termination. He or she will also want to explore your history of working for this employer and whether you were reprimanded for bad conduct in the past, whether you were written up, whether you suffered from performance problems, and whether any evidence of discrimination, harassment, or retaliation may exist. The analysis and decision of whether to sign the release. After the facts have been hashed out, your attorney will let you know if he or she believes you may have a basis for a legal claim against the employer, both as to the termination itself and also as to other matters, including wage and hour violations, etc. If there is no known good basis for a claim, it may be best to just sign the release and get your severance and start looking for a new job. On the other hand, if a claim looks like it may exist, you'll need to weigh the pros and cons of taking a small severance against giving up a potentially substantial dollar damage claim against your employer. Bottom line, if you believe you have a substantial monetary claim you can win, you may wish to forego the severance altogether and instead gear up for a lawsuit against your employer. In the end, if you sign a release, both your existing known and your existing not yet discovered legal claims against the employer, including as to negligence, violation of employment laws, injuries, wage and hour violations, etc., all of that will be forever terminated and evaporated for all purposes. They will no longer be actionable, and if you try to later sue for those things, your employer will use the signed waiver as a complete defense. The moral of the story? Don't rush and make a rash decision. Try to slow the process down and buy time to consult with an attorney first. Otherwise, you may kick yourself when you later discover you inadvertently waived the right to a substantial claim for a few weeks or months of severance pay. Call Benjy Law Corporation for a free consultation. We offer a free 1-hour legal consultation with an experienced attorney. This can be done either in person at our office in Beverly Hills, California, remotely via Zoom or FaceTime, or telephonically. The consultation is free of any obligation and completely confidential and protected from disclosure to third parties by the attorney-client privilege, even if we are not ultimately retained as your legal counsel. To make an appointment, please call us at 310 area code 203-2650 or email us at info@benjylaw.com. That's info at benjy like yellow law.com. This concludes this video. We hope you found it informative and useful.